As we repeatedly say on the MeidasTouch network, MAGA stands for Make Attorneys Get Attorneys, and Donald Trump's lawyers, Alina Habba and Cliff Robert, are, in my opinion, in very big trouble after not candidly disclosing to Justice Arthur Engoron when he asked about the status of the plea negotiations of Allen Weisselberg, who on Monday pled guilty to multiple felony perjury counts in connection with his false and perjurious statements during the New York Attorney General's civil fraud case, both during depositions and at the trial itself. There is a concept under the law called suborning perjury, and there are serious issues now being raised and questions being asked if Alina Habba and Cliff Robert were involved in suborning perjury. And those questions, I think, will need to be resolved forthwith. Also, under New York's rules of professional responsibility, specifically Rule 3.3A3, it provides that if a lawyer's client offered material evidence and the lawyer comes to know of its falsity, that lawyer shall take reasonable remedial measures, including, if necessary, disclosure to the tribunal, which Alina Habba and Cliff Robert have not done, even after Justice Arthur Engoron gave them the opportunity to do so. So recall that back on February 5th, 2024, Justice Arthur Engoron sent an email to all of the lawyers in the New York Attorney General civil fraud case. And here's what it said. Dear counselors, as you are undoubtedly aware, in an article in the February 1st, 2024 online edition of the New York Times headline, Trump's former finance chief in negotiations to plead guilty to perjury. It then says the authors of the article, they wrote that defendant Allen Weisselberg is, quote, negotiating a deal with Manhattan prosecutors that would require him to plead guilty to perjury. What's more, he would have to admit that he lied on the witness stand in the case pending before me and during a pre-trial interview plaintiff conducted. As the presiding magistrate, the trier of fact, and the judge of credibility, I of course want to know whether Mr. Weisselberg is now changing his tune and whether he is admitting he lied under oath in my courtroom at this trial. Although the Times article focuses on the size of the Trump Tower penthouse, his testimony on other topics could also be called into question. I also may use that as a basis to invoke a doctrine falsus in uno. When you lie in one, you lie in all. Justice Engoron states, as the article notes, perjury, particularly in a high-profile trial, undermines the broader ends of justice and cannot be ignored. I do not want to ignore anything in a case of this magnitude. By Wednesday at 5 p.m., please submit to me what you know and what your response is. Signed, Justice Arthur Engoron. So Engoron says, look, I'm getting ready to write a decision, which he ultimately issued, and these issues are material to my decision. You, Alina Habba, you, Cliff Robert, you both represent Allen Weisselberg in addition to Donald Trump. You need to let me know, you represent the co-defendants. You need to let me know what's up here because perjury is a very serious thing and it could impact the decision that I ultimately make as a judge, as I make my order. So then Alina Habba responded like this. Dear Justice Engoron, this letter is submitted in response to an email correspondence by you dated February 5th, 2023. That's the one that I just read for you, wherein Your Honor referred to a recent New York Times article entitled Trump's former finance chief in negotiation to plead guilty to perjury and requested that counsel for both sides disclose anything we know about this that would not violate any of our professional ethics or obligations and provide a recommendation as to how Your Honor should address this matter, if at all, including the timing of the final decision. Pause. Alina Habba, you represent Weisselberg. So you have evidence at this point in time that he was lying, and Justice Engoron's asking you, what do you know about this? Because he's your client in this case before me. Habba goes on to say in her letter dated February 7th, 2024, as your honor is aware, my office represents Mr. Weisselberg in the instant civil litigation. We do not represent him in connection with any criminal matters. I have not spoken with the New York District Attorney's Office about any of the matters discussed in the New York Times article. Further, in an abundance of caution, I have conferred with my ethics counsel and have been advised that I am constrained by my professional ethical obligations from providing any further detail. No adverse inference should be drawn from my inability to respond. As for how your honor should address this matter, no further action is necessary or appropriate. Matters outside the record, such as outside media sources, cannot influence the court's perception of this case or taint its view as to whether Mr. Weisselberg is a credible witness. Now, upon information and belief as of this letter sent by Alina Habba, February 7th, her own client knew that he perjured himself, and she is on inquiry notice to know that because Justice Engoron is telling her in the email. You have ethical obligations as a lawyer not to withhold this information, but you need to share it, Alina Habba, as an officer of the court. Not only does Alina Habba respond, but Cliff Robert responds, one of the other lawyers for Donald Trump in this matter. And Cliff Robert comes out and basically starts attacking Justice Arthur Engoron. Says this article speculates about purported plea negotiations involving Mr. Weisselberg and the New York District Attorney's Office regarding unspecified allegations of perjury, this February 7, 2024 letter states. The article simply does not provide any principled basis for the court to reopen the record or question the veracity of Mr. Weisselberg's testimony in this case. Indeed, we respectfully submit that the court's request for comment on this speculative media account is unprecedented, inappropriate, and troubling. So you have Cliff Robert, Trump's lawyer, attacking Justice Arthur Engoron for following the judge's ethical responsibilities to say, was a crime committed in my courtroom by one of the co-defendants who you all, Habba and Cliff Robert, should know about. And Cliff Robert saying, you're just speculating. You know nothing about this. How dare you even ask us this question? So what does Engoron do? Engoron responds in an email on February 8th, 2024. And this is where he really gives those lawyers the warning and says, okay, I hear you, but if I find out later that Alan Weisselberg committed perjury, there will be consequences. Watch what Engoron says. Dear Mr. Robert, when I sent my straightforward, narrow request, that's the first email I read for you, for information about possible perjury by Alan Weisselberg in the subject case, I was not seeking to initiate a wide-ranging debate with counsel. However, your misleading response grossly mischaracterizes the letter that I wrote, and I feel compelled to respond. Arguing against judicial notice is attacking a straw person, as I have not taken, do not plan to take, and did not suggest or hint that I would take judicial notice on the subject New York Times article or the contents thereof. Similarly, I have not taken, do not plan to take, and did not suggest or hint that I would take the Times article into consideration in my findings of fact. Similarly, I have not planned, do not plan, and did not suggest or hint that I would invoke falsus in uno based on the story. Any such invocation would be based on his trial testimony and or a guilty plea. However, if tomorrow Weisselberg publicly confesses to having committed perjury about a significant matter in the case before me, or if he pleads guilty to such perjury at any time before I issue my final decision, I will research and consider what the law allows. I take seriously my obligation to find the facts and determine the truth. To that end, I find it appropriate to have reached out to counsel for Mr. Weisselberg, who is a defendant in this action, to inquire as to her knowledge of this serious allegation. Indeed, Rule 3.3 sub A3 provides that, quote, If a lawyer's client offered material evidence and the lawyer comes to know of its falsity, the lawyer shall take reasonable remedial measures, including, if necessary, disclosure to the tribunal. This obligation applies, quote, even if compliance requires disclosure of information otherwise confidential. To, quote, know of the falsity, to quote, know of the falsity, the lawyer must have actual knowledge, but such knowledge, quote, may be inferred from the circumstances. You and your co-counsel have been questioning my impartiality since the early days of this case, presumably because I sometimes rule against your client. That whole approach is getting old. What Justice Engoron did right there is basically say, actual knowledge may be inferred from circumstances. For example, I'm telling you that I'm on notice that Alan Weisselberg may be negotiating a plea agreement, and you should have actual knowledge right now as of my past email. But if that's the approach you're going to take, let me cite Rule 3.3 sub A3, which are the ethical rules that lawyers must follow, because there may be consequences later. And think about these consequences from a materiality standpoint, that now an order has been issued. Don't get me wrong. Justice Engoron issued a very powerful order where Donald Trump's responsible now for $464 million in pre- and post-judgment interest. But for his analysis to have learned that Weisselberg was committing perjury and they were relying on Weisselberg as part of their testimony, and that there have now been applications made to the appellate division, all of this where Weisselberg was lying, that has real implications right there, where the penalties may have been more severe or serious. In my own personal opinion, in conclusion, I don't think Habba and Cliff Robert are just going to basically walk free and nothing's going to happen to them. Just in my own opinion, and I'm just sharing opinions here as a lawyer, I would view what they did as a violation of Rule 3.3A3, and others can disagree with that. But I think it's, in my own opinion, a clear-cut case. Share your opinions, but I think there will be real ramifications there. We'll keep you posted as we learn more, and I expect to be hearing more about this soon. I'm Ben Meiselas from the MeidasTouch Network. Thank you for watching. Hit subscribe. We're on our way to 3 million subscribers thanks to your incredible support. Have a great day.
Hey Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.